Originally, back in '05, we prosecuted Deanna Laney for capital murder. We did not believe when we prosecuted her that she was insane. Obviously, we believed that she was sane and that she was guilty of the crime she committed. The jury obviously disagreed with me and found that she was not guilty by reason of insanity. And the jury listened very attentively to the evidence. I know some of the jurors I've come to know since the trial personally, and I know that it was a very difficult case for them emotionally. They put a lot of time into it, and we're very respectful of their decision. And whether it was they agree with my position or not, I certainly respected their decision. I know that they really put a lot of thought into their deliberations, and were heartbroken at what had happened to the children. Once she's found not guilty by reason of insanity, she at that point is not convicted of a crime, and the focus shifts then from being something of punishment to treatment. Every year she would come back up for recommitment to see if the evidence was there to meet the criteria for recommitment under Chapter 46B. Every year we have either gone down there and argued for recommitment, or she has agreed to be recommitted. Mm-hmm. This year, she felt like, in Kerrville State Hospital said that she needs to be released. A number of years ago, it might have been, I don't remember, the '06, or not long after she had arrived there, maybe a year after she arrived at the hospital, Kerrville was allowing her furloughs with her parents. We found out about it, and
what year was that?
I can't remember the exact year. She'd been there maybe a year and a half.
Okay.
And myself and April Sykes, the first assistant, went down and brought that to the attention of Judge Kent, and Judge Kent had not been aware of it, and she stopped Kerrville State Hospital from allowing her to leave the premises of the hospital in the custody of her parents. We have fought to make sure that if there's evidence out there that will meet the criteria for recommitment, that we find it and bring it to the court's attention. This year we did the same thing. We looked for any evidence. We went through every medical record that she's had since she arrived at the hospital, over 7 years. I mean, there was thousands and thousands of pages. We talked to Dr. Grapon, probably up here working on it for a week straight. And that was after we'd gone through all the records ourselves, and he had as well. So after we'd read all the records, we got together for probably a week and made sure we were not overlooking anything. We talked to Dr. Resnick and Dr. Reed. Dr. True, who is the director of Kerrville State Hospital, these are all psychiatrists, medical doctors, was very cooperative with us.
When did you talk to them?
Oh, this was in preparation for the hearing in November.
Okay.
Because we knew that we were going to call them as witnesses.
Okay.
And elicit testimony, because we wanted to make sure that if there was anything out there that would help meet the requirement for recommitment, that we did not overlook it. All the doctors testified that she was not currently mentally ill, that as they testified, if they're not currently mentally ill, they can't be confined in a mental hospital. And it's one of those things where, whether I agree with it or don't, or not, myself and just as Judge Kennedy is bound by what the evidence shows. No matter, and I can only speak for myself, but no matter what your personal feelings may be, you have to go with what the evidence is. And when you're in the original trial, the circumstances in the offense, all that is relevant. Once she's found not guilty, then what becomes relevant is just what has occurred during her treatment. what the law looks to in the original trial is not just the doctor's testimony, but you can argue the circumstances. Well, she did this or she did that, and that all indicates that she was sane. When it comes down to once she's found not guilty, then what you look at is what the medical experts say. Insanity is not a medical term; it's a legal term.
Okay.
So what the doctors do is they look at in the original case, they look to determine if they look at the legal definition of insanity, and they render an opinion as to whether they think the evidence in a mental health context meets that legal definition. When you get into the treatment and whether or not she meets the criteria for recommitment, it is all about what the doctors say. That's what you look at. The facts of the case are no longer pertinent. She's already been found not guilty.
Okay.
It's very, when we had this hearing, we didn't go down there as the state and just agree to it. We wanted to have the hearing. This is one of those cases that at some point, when I'm gone from this position, there are cases that you will take with you, and there are been here a long time, and this is one of those cases that you just take with you, just like the jurors will, and I'm sure the defense lawyers do, and Judge Kent. It was just a very difficult case emotionally, and knowing what had happened. But when you get to once she's found not guilty by reason of insanity, and you're focusing only on the treatment part, you have to be able to set the emotional side of what she did, I guess, kind of aside and look at the evidence, and that's difficult. Because it's hard to get to this point, emotionally. But Judge Kennedy, and I can't emphasize it enough. She made the decision that the law required.
Right.
And I looked at everything I could to see if there was something that could meet the burden for recommitment, the burden of proof, and there wasn't anything. I mean, there was absolutely nothing out there, and a lot of people say, well, she killed two kids, and yeah, I mean, she did, but we cannot come in and argue that in a recommitment hearing. All that is you can argue is that's something at the trial of the case. So you just look at, is she currently a danger to herself and or a danger to others, or is she suffering from emotional or physical deterioration that prevents her from living independently? And it's all about what the doctors say. In this case, every doctor that we called, and we called every doctor that had evaluated her over the 7 years and that had personal knowledge of her condition, not just someone to come in and render opinion. These are the people that have been with her over the 7 years.
Those doctors were?
Yes.
They've been treating her for, okay.
Yes. Well, like Dr.
The
True.
ones listed in the...
They have Dr. Rapon has seen her, Dr. Resnick and Dr. Reed have, and Dr. True is the director of the hospital she's been in, and she's seen her personally. So these were people that had seen her over the 7 years.
Okay.
They all reviewed the records. They all, had been involved in this over the time, and all of them came in, and it wasn't just like Dr. Reed was the psychiatrist appointed by the court. Dr. Rapon was my expert I hired. Dr. True was the director of the hospital, and Dr. Resnick was a defense expert. So we had my expert, the defenses, the courts, and Kerrville State Hospital.
In the November hearing? Okay.
And what it came down to was them saying that she is not currently mentally ill, that she has responded to the treatments, and is not currently mentally ill. And I guess I think a lot of people that were here when this case occurred obviously remember it, and will be probably, it'll be hard to comprehend or understand. And all I can tell them is, I understand how they feel, but what we have to do is look to the evidence we have, and at this phase it's all about what the mental health experts say.
Right.
And you have to look to them like the law requires. That's what the law says you look to.
Right.
And you take their opinions and the medical records and you look to that to determine if there's
Okay.
evidence that meets the requirement for recommitment. In this case, there was not any.
Okay.
And Judge Kennedy
Okay.
ruled the way that the law required. And
Right.
it's not something. No one went down there and said, well, it's been long enough.
Yeah.
It was not like that. It's one that we have to go by what the mental health experts say. I cross-examine. I ask them questions. They were asked questions by the court,
Mm-hmm.
the defense lawyers. So everybody asked every question we could think of. I know we did to say,
Yeah.
hey, if there's anything out there. I mean, I'll tell you, I wanted to find something.
Okay.
I mean, I was looking very hard to find something because I didn't want to miss something, and I mean, honestly, I wanted to find something that would have, but I couldn't. There was nothing, and I went through.
Did she actually testify, or did she say anything during the
No,
hearing?
no, and
And you don't know when she was released?
I don't.
Okay.
I don't know.
Do you know where she is now?
Well, there's
Or
part of this is sealed,
Okay.
and so there's by law I don't know where she is currently. I know parts of where she will be and all that, but I can't
Okay.
say. It's it's one of those things that it's hard for people to understand. I think people come into with the misconception that if you do something like this that you're going to be gone forever. It's just
Yeah.
not. It's just not the case. Some people, Dana. Some people are found not guilty by reason of insanity, and they are in the hospital for years and years and years and years.
Mhm.
Some people will be there, for 20 years, 30 years. Some people are there a year.
Mm-hmm.
Some people, there are ladies. I know Deanna Schlosser out of Plano, I believe was who it was. She was situated much like Deanna Laney is, and was there for a year or so. Maybe a little bit longer, and there will be some that'll be there longer than Deanna Laney. And it's one of those things. The hard part is to separate your emotion in the case
Mm-hmm.
from the fact that she was found not guilty by reason of insanity from a Smith County jury, and so at this point, it's that her being in a mental health facility is not punishment. You can't keep her there to punish her.
Okay.
It's
I understand.
the law says, well, we don't just keep her there to punish her. If she reaches a point in her in her mental health where in her treatment and I guess recuperation,
Yeah.
if she reaches a point where she does not meet these criteria, she has to be released.
Okay.
And in looking at that, you look to what the experts say, and that's what we did through.
Basically, if she's not a threat anymore, she can.
Yeah, basically what they say is, and there's a long list of 1, 2, 3 ands and ors, but essentially
Okay.
what it says is, if she's not a danger to herself, not a danger to others,
Okay.
and there's not a substantial deterioration to her physical or emotional condition that would require that prevents her from living independently, and that's all in the order, then she cannot be committed. You can't. Basically what they're saying is, if the person's not mentally ill, you can't keep them in a mental hospital.
Okay. If she can live on her own, and if she's not a threat to
Right,
others or herself.
Right, and basically that she was not
Independently.
experiencing substantial mental deterioration of her ability
Okay.
to function independently.
And no substantial.
Yeah, and I'll show it to you. I'll make
Okay.
you a copy of it.
Okay. And let's see. Can she change her name? Can she leave wherever she is now? And I mean, is she legally?
I can't tell you what the treatment plan is.
Okay.
I can tell you that I believe any concern that people may have has been addressed in the treatment plan. Although I cannot tell you the specifics of it. It's a very
Okay.
long and detailed aspect of her of this order. So
Okay. And are there certain conditions that she's got to meet, or
well, there's,
you can't say?
yeah, I mean, it's, you know, it's just it's a document that addresses, you know, there
Is that
there are
sealed?
things.
The treatment plan is
Yeah,
sealed?
it's sealed.
Okay.
So,
Okay.
you know, that's really kind of what I can tell you. You know, I just, you know, you know, everybody followed what the law says, and
Yeah.
and you know what the evidence showed.
Right.
And you know, everybody, and I think someone asked me, well, what are you mad? Do you disagree with it? Well, you know, I argued that she was, you know, in the first, initially I argued she was not insane. You know, I argued that she was sane, but that was not the finding, and I, you know, I have to go with what the jury said, and I respect their service and their
Yeah.
decision. I really do. I mean, I know two of the people on the jury. I've come to know them very well. And I'll tell you something, that jury went back there, and it was a difficult decision. They did.
How long did they deliberate, do you know?
I can't remember. It's been, you know, I know it was emotional for them.
Mm-hmm.
And, you know, they really put a lot of thought into the evidence,
Yeah.
and came out with their decision, which I respect. And from that point then, it's not a criminal case any longer. It's a civil case.
Okay.
And so because it's not a criminal case, the law says she has not committed a crime.
Okay.
You know, whether I...
And that's why the hearings were sealed and all that.
Yeah. And, you know, the thing is, you know, even though I, you know, felt like she had, and I still maintain my opinion on that, everybody else disagreed with me, but, you know, as far as the system, from strictly a legal perspective, everything has been done that can be done to determine if there was evidence that would meet the requirements for recommitment. And
Okay.
there just wasn't any, although I can tell you we looked hard, and on a personal level, I wanted to find it.
Okay.
But it wasn't
Yeah.
there, and I really want to put in there, you know, and especially if you can quote me on it, but I mean, you know,
Okay.
Judge Kennedy gave us all the time that we needed to present every bit of evidence we could. She asked questions, and you know, she gave us all the time we needed to investigate it and to put on whatever we wanted to put on. She was, I think, very, she asked questions as well, and you know, she came to the decision that she followed the law and made the decision that she had to make based on the evidence.
Right.
You know, not a decision based on her, you know, and I don't know what her personal beliefs are, but you know, she followed the law and made the decision based on the evidence.
Okay.
You know, and I don't know if people just like I am, they're going to be emotional about it.
Well, that's all you can do is follow the law.
It is, and I'm telling you, I can't. It's hard to explain. It's tough because, you know, I remember when the case was tried. You know, there were some lawyers saying, "Oh, she'll be in that place longer than she would have been if she'd been convicted," and that's just not